So first, what is the main purpose of the Brussels regulation in Europe? So the regulation is used to determine jurisdiction, as I'm sure all of you guys know from your readings. And jurisdiction pretty much means which courts will have the power to adjudicate in civil and commercial matters, including torts. Um, so before we get into the scope of the regulation, I would like to remind all of you guys that when interpreting the Brussels Convention, the Court of Justice has underscored that the use of its words and concepts has potentially varying meaning across member states. Therefore, what we need to keep in mind when we read the words here is that each meaning has an autonomous interpretation, which means that pretty much the European Union assigns its own meaning to these words. So, for example, if we look at two different jurisdictions, they might have a different meaning as to what commercial might mean. Hold up, let me see. I see something in the chat. We get the slides at the end of the meeting. I joined a few minutes late if you already answered this. So theoretically, yes, it is marketing that is in charge of this. It is not me. I can ask to marketing and get back to you guys. I think there's a group chat for all of you guys regarding Athena studies. I'm not yet in this group chat, although I will be joining soon. And when I do get the link, I will make sure that you guys get the slides. But no worries about being a few minutes late. We haven't gone over anything yet, Max. Okay, so pretty much what this means is that interpretation is grounded in a common meaning applicable to all member states rather than being conducted individually. So if any of you guys are familiar with, what specific words might mean in your own jurisdiction, forget about it when looking at this regulation. You want to focus on the European meaning. So for example, torts might have a different definition under the Brussels regulation than it would in the Netherlands or in France or in Italy or in Germany and so on. Um, so this is applicable when looking at the material scope of the regulation. So according to Article 1, Subarticle 1 of the regulation, it applies to civil and commercial matters, excluding revenue, customs, administrative matters, and the liability of the state for the exercise of its authoritative powers. Okay, so these exclusions are to be found in Article 1, Subarticle 2. So this list is exhaustive. This list of exceptions is exhaustive, which means that there are no other forms of matters that do not fall under civil and commercial. So as long as they're not revenue, customs, administrative, or liability of the state for the exercise of its authoritative power, then it will fall under the civil and commercial matter scope. Um, what's important to keep in mind here is very early on we get introduced to a case, so to some European case law, which is Owusu versus Jackson, which does specify that international character is required, which means at least two of the countries involved are member states. Um, there are a couple of exceptions to this later on in the regulation, but I doubt that this is something too relevant for you guys. But okay, and finally, one last requirement under Article 1, Subarticle 1, is that it must be a matter brought before a court or a tribunal. Okay, so in interpreting civil and commercial matters, the European Court of Justice held as the main rule that disputes or judgments involving a public authority and a person governed by private law, where the public authority acts in the exercise of its power, are excluded from the scope of application of the regulation. Okay, so for example, tax disputes or so on will be excluded. Um, Also, make sure that you keep in mind this international character thing when looking at disputes. And make sure that both countries are member states, because I remember that in my private international law exam, I lost a point because I failed to identify that, ridiculously enough, my professor had put a country that wasn't part of the European Union, and in the rush of like writing the exam, I didn't even clock it. I just went ahead and wrote and analyzed the disputes. So yeah, just keep that in mind. Although I doubt you guys are gonna, I mean, I don't know who your professor is for private international law. Mine was particularly mean, let's put it that way, and so she did that. But yeah. Um, okay, so the regulation scope is subject to limitations based on its relationship with other international instruments, both conventions and provisions of EU law. Um, so what does that mean? It means that precedence is given to rules about jurisdiction, recognition, and enforcement in other instruments of EU law, including the national laws, harmonized through the implementation of directives, and to conventions to which member states are parties and which govern jurisdiction or recognition and enforcement of judgments in particular matters. So once again, this is usually not that relevant for you guys on an exam, but it is something that you still want to keep in mind. It's something that you want to know when looking at these kind of regulations. It derives from a Latin concept called lex specialis, which pretty much means that when there is a specific rule governing a matter, it will usually override a general rule which will apply to that matter and other things. So yeah, that's the concept of lex specialis, and it means that other more special rules governing a specific matter might take precedence over the Brussels. But since you guys are studying just the Brussels, it is enough to know that you don't have to know any specific examples. Okay, so quickly, let me ask you guys. You can answer in the chat. You can turn your mic on, whatever you want. But let me ask you guys this question. Do you think that the Brussels regulation would apply to an appeal to an administrative organ by a citizen? What do you guys think? Yes or no is fine. You don't have to specify why. Just say whatever you're thinking in the chat or turn on the mic. Don't worry about it. Like I remember when I was like learning this thing, I was also I never wanted to raise my hand in class or so on, but here we're all among students. I'm still a student too, so feel free to either drop a yes or no, whatever you guys think it is. Okay, so Luca says no. Okay, everybody's saying no. Very good, guys. That is correct. So there are two reasons as to why. So here there's only written one, but there are two reasons. So the first one is that Article 1.1 states that the regulation applies whatever the nature of the court or tribunal. And here we're talking about an administrative organ, which is not a court or a tribunal. But this is maybe the less obvious reason. The more obvious reason is that there is a clear exclusion under Article 1.2 that administrative matters are excluded from the scope of this regulation. So that is why it would not apply to an appeal by a citizen to an administrative organ. Okay, now let's get to the, as we say in Italian, the juice of the regulation. Hmm. Let's take a look at the main rule. So you might have seen in class that the way that the regulation works is that it has a hierarchy of rules, right? So you have ranging from exclusive jurisdiction to weak party rules and so on. You have a hierarchy of rules. So this is at the bottom of the hierarchy. This means that these rules here apply practically always in almost any scenario. And when something more specific applies, so let's remember before the lex specialis principle, then those will usually take precedence over this rule. But usually this rule always can appear as a backup. So the primary jurisdictional principle of the regulation dictates that persons domiciled in a member state must be subject to legal proceedings in the courts of that specific member state. This is also known as forum domicilii, and it is clearly outlined in Article 4 of the Brussels regulation. So it is emphasized that the domicile of the plaintiff and the nationalities of the parties are, in principle, considered irrelevant. So the logical consequences of this rule are that the courts of the country of the defendant's domicile cannot refuse to try the case. This is also known as the doctrine of forum non conveniens, and it can only be used in specific instances of another thing called the lis pendens, which is a totally different thing. Also, courts in other member states are generally obligated to dismiss the cases due to a lack of jurisdiction. And finally, a person domiciled in a member state may or must be sued in another member state only in situations explicitly permitted by the regulation. And these are articles that, once again, we will look at later on. Something to keep in mind is that if the defendant is not domiciled in a member state, then the jurisdiction may be determined by the forum's own national jurisdictional rules. This also is a complication that I don't expect you guys to know about or to have to learn either. But so an example of this can be, as we can see at the bottom of the slide, uh, actually for the time being you can ignore that example. Let's think about instead if me as an Italian I want to sue a person who is German. What this main rule says is simple. That person is domiciled in Germany. Thus, I shall have to go to a German court in order to sue that person. Um, so another important thing is how is the domicile of a person defined? So when it comes to natural persons, we can usually just assume that the nationality that you get referred to on, for example, an exam question is going to be the place of domicile. So if it says a French person, then you can just assume it's France. Obviously, if they're domiciled elsewhere, they will tell you themselves, a French person domiciled in Poland, for example. Instead, for companies, the domicile is usually the place of the statutory seats, which is, or the place of central administration, or finally, the principal place of business. Once again, this is something that on the exam you guys would probably be told. Um, okay, so for example, let me ask you guys a question. Where should a company domiciled in Hungary initiate proceedings against a company domiciled in Spain? Exactly, exactly. Yeah, thank you, everyone. So the answer is Spain, yes. And this is because Article 4, Subarticle 1 states that a company domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. Okay, so now that we have the first main article cleared out, let's move past and let's go towards the special, a form of special jurisdictional rule. Hmm. So the main jurisdictional principle, the one that we were looking at just now, the forum domicili, Article 4, is subject to some important exceptions, such as, for example, Article 7. So let me remind you guys of the hierarchy. This is something that is always important to remember. Matter of fact, I'll go through this and then I'll remind you guys of the hierarchy so we can just make sure that we're all keeping this in mind as we go through it. Um, So, what Article 7 does is that it offers the plaintiff the option to sue the defendants in other member states other than the one where the defendant is domiciled. And this is usually the case because maybe the disadvantages that the defendants might incur are considered less important than the closer connection that the dispute holds with another member state, which makes which overall as an exception makes the disputes more suitable for adjudication in that other member states. Okay. And also something that I want you guys to keep in mind as we go through this is that these special jurisdictional rules do not deprive the plaintiff of his rights to sue the defendant in the member state of the defendant's domicile, but rather they offer the plaintiff an additional alternative choice. Uh, Okay, so let's look at application as regards contractual obligations. So this is Article 7(1)(a). So here the Court of Justice has chosen to adopt a broad interpretation of Article 7, which expanded its scope considerably. So jurisdiction under this article is at times established based on disputed facts that are not only relevant for determining jurisdiction, but also for the substance of the claim. This is a bit of a technical comment. What you guys need to know here is that when there is a dispute arising out of a contractual obligation, then usually the place where the dispute, the courts of the member states before which the dispute can be brought is going to be the member states where the place of performance of the contractual obligation should occur. Um, So here, the concept of a contract is interpreted autonomously. Okay, so let's remember before we said that an autonomous interpretation means that the European Union has their own definition of what autonomous is. So what this means is that it is independent of whether the relationship is classified as contractual in the national law of the member states or the law governing the relationship. Okay, so for example, um, let's say that under the regulation, for me to make an agreement with, I'm going to pick a name at random here in the list of people that are in the class. Okay, so let's imagine that Agnese and I made an agreement, and we simply write on a piece of paper. We say, okay, this I, Eduardo, will fulfill this contract with Agnese, and the place of performance shall be Germany. Okay, let's imagine that in Germany, in order to actually complete an effective contract, the rules of Germany say, well, for a contract to be effective, the contract must be written by a lawyer. Okay, so what autonomous interpretation means is that it does not matter that German specific rules say this. If under European law, and here specifically under the regulation, it is fine for us to just sign a random piece of paper and say this is a contract, then this shall be considered a contract. Okay, and this is important because otherwise the regulation could often be invalidated because at that point in the situation of a dispute, if for example Agnese tries to sue me in Germany, I could just come and say, well, you know what? The contract that we signed is actually not a contract here under German law, and therefore we cannot have a contractual dispute. She cannot sue me in Germany. She must sue me in my place of domicile. So she must sue me in Italy where I am domiciled. Okay, so that's why it's important to keep in mind this concept of autonomous interpretation. And I know this sounds overly complicated. Once again, I just like to explain things fully. The real important part of this provision is to simply keep in mind what Article 7.1a says, that it is the place of performance of the contractual obligation. So the country where the place of performance is where we have to start, is where we have to bring the dispute. Um, okay, so now let's look at 7.1b instead. So Article 7.1b refers to the sale of goods and to the provision of services. So in a scenario of sale of goods, the place where the dispute shall be brought is the place where the goods were or were supposed to be delivered. And finally, instead, in the case of provision of services, it will be the place where the services were provided or should have been provided. Okay. So, one last detail that we should keep in mind here, which is 7.1c, and this is a bit nonsensical, okay? I don't expect you guys to understand why it's like this because personally I don't understand it either. I don't think even our professors do, but what Article 7.1c says is that we should check Article 7.1b before 7.1a. This is just one of those little tweaks that those geekers in the EU drafting segment have decided to turn this stuff around. But okay, so basically, always check 7.1b first. So if your professor in your exam gives you a dispute, check first if it is a sale of goods or provision of services. If it is not, and therefore it doesn't fall under Article 7.1b, then you can go and check Article 7.1a and discuss the place of performance. Okay. So thinking of an example of a provision of services, we can imagine a Portuguese window cleaning company which agrees with a French company to clean their skyscraper in Paris. Since Paris is where the service will be performed, French courts will have jurisdiction in case of disputes. But to make this even more international to show you guys the power of this regulation as to how it can establish jurisdiction. Let's imagine that it was a Portuguese window cleaning company agreeing with a French company to clean their skyscraper in Belgium, for example, or yeah, in Belgium. So, since Belgium is where the cleaning will take place and thus where the service will be performed, Belgian courts will be the ones to have jurisdiction, despite it being a Portuguese company providing the service and a French company accepting the service. Okay. So when looking at this, we need to keep in mind that the place of payments is deemed irrelevant for these two types of contracts. So if an agreement is made on the place of performance, which is not intended to determine the actual place of performance, but only to establish jurisdiction indirectly, it won't have effect. Um, unless there's a choice of court agreement, and that is something that we'll get to after. Um, Okay, let's look maybe again quickly at another example here. We'll add a question. So a Dutch cheese producer sells their products to a Belgian cheese shop domiciled in Antwerp. The Belgian cheese shop arranges for a truck to pick up the cheese at the production facility in Amsterdam. In case of dispute, where could the Dutch producer initiate proceedings? What do you guys think? Do you guys think it would be the Netherlands or Belgium or elsewhere? What do the facts tell you? So we have a Dutch cheese producer, which we can assume is domiciled in the Netherlands. We have a Belgian cheese shop that is domiciled in Antwerp, so in Belgium. Oh, let's see, there's an answer. Okay, so Paul and Lucas say the Netherlands. That is that is correct. It would be the Netherlands. And this is because, as we saw before, in the sale of goods, it is the place of delivery of the goods which shall have jurisdiction. So here we see that the delivery actually occurs in the Netherlands because the Belgian cheese shop picks up the goods in Amsterdam. Okay, so that is where the goods are exchanged between the two parties, and thus would be the Netherlands. But here comes a warning that I want you guys to keep in mind always. When looking at this rule, when looking at Article 7, remember that uh, it does not deprive the the claimant of the possibility to also use the main rule, which is Article 4. Okay, so Article 4 says that a defendant shall be sued in their member states. So here the answer is both the Netherlands and Belgium. Well, the Netherlands or Belgium. I guess, the Dutch cheese producer would choose one of these two places to do. So, once again, the Netherlands, because Article 7.1b states that in contracts for sales of goods, the place of delivery of the goods shall have jurisdiction. However, the Dutch company may also use the main rule, which is Article 4.1, as we saw before, and they may sue the Belgian shop at their place of domicile, so also in Belgium. Okay, is that clear for everyone? I'll wait a couple of seconds, and if it is, then we can move forward. But if you have any questions, please go ahead and ask them. Okay, then let's move forward. Let's look at another special jurisdictional rule, still under Article 7, and here we look at Article 7.2. Okay, so we look at matters relating to torts, delicts, or quasi-delicts. So In disputes regarding matters of tort delicts or quasi-delicts, a defendant domiciled in a member state can be sued in the courts of the member states of the place where the harmful event occurred or may occur, also known in Latin as forum delicti. So the meaning of the expression acknowledges, according to the ECJ, that the claimant has the option to commence proceedings at the place where the damage occurred or at the place of the event giving rise to it and is the origin of the damage. And this is according to the case Handelsveckerij Bier versus Mine Potest d'Alsace. Um, so this sounds a bit confusing, and to break it down into maybe a simple example, we can imagine, I don't know if you guys know, but in the Netherlands and in Belgium, well, there is a small town which sits on the border of both the Belgium and the Netherlands, and it is divided by a line. So the border is clear cut, and half of the town belongs to the Netherlands, and the other half belongs to Belgium. Okay, so let's imagine here that it is New Year's Eve, and I decide to, well, not me, I do not want to hold myself liable for anything. Let's imagine someone, Marco, decides to light fireworks on the Dutch side. So the fireworks are going up, everything is exploding, it's beautiful, everyone's having a great time, but then a firework malfunctions, flies over the border, and flies through the window of Elise and explodes in her living room. And her couch and her furniture is destroyed. Okay, so if Elise wanted to sue here, she would be allowed to she would be allowed to sue both in sorry, the security of my library just walked past and tweaked me out. He looked straight into my soul through the window. I got distracted for a second. I'm sorry, let me wrap it back. So Elise would be allowed to sue both in the Belgium because that is where her house is, that is where the damage occurred, that is where the living room well, that is where the firework exploded in the living room, but also in the place where the event giving rise to the damage took place, which is where I lit off the firework. Okay, that is kind of an exact, which would be the Netherlands. So Elise here would have two forms, both the Netherlands because I lit off the firework there, and Belgium because that is where the damage occurred. Okay, and then imagine, once again, I'm Italian, maybe I'm domiciled in Italy. She has one last option, which is to even sue me in the courts of the member state where I'm domiciled. So Italy. So let's remember that is always a possibility. Okay. Um, okay. So the courts for the place of the events giving rise to the damage has jurisdiction to deal with the total resulting damage, while the courts for the place of the damage uh, has jurisdiction merely in respect to direct and immediate damage arising in that country. Um, yeah, that's a bit more it doesn't make sense to go to it too much in depth. I think the example I provided you guys with already covers enough of what you guys have to know. Um, Also, it is required here that the damage has arisen or be at risk to arise in a member state. Uh, and the benchmark to establish jurisdiction is claiming that a damage has arisen or that the issue of actual existence and extent is a matter of merits and should not be decided to establish jurisdiction. And when the damage has arisen or has the possibility to arise in several member states, the plaintiff can make a choice between instituting parallel proceedings in each member state regarding the damage that arose there, suing as regards the total damage in the member state of the harmful acts, or to sue the defendant where they are domiciled. Okay. And so here, once again, autonomous interpretation. Let's remember what we said before, the European Union's own meaning of these things. So under torts, delicts, or quasi-delict, the ECJ understands it to encompass all liability which does not relate to a contract. Okay, so what we mean by that is that any kind of liability that will not fall under 7.1, which talks about a contract, then that will fall under 7.2. Okay. So let's imagine here a scenario which, I actually saw play out more or less. It's a little bit exaggerated, but I saw something similar play out. There weren't legal disputes involved, but I saw this over a carnival that I spent in Maastricht 2 years ago because my brother actually studies in Maastricht. Well, he just graduated from Maastricht and I used to go to visit him. So let's imagine here that an Italian tourist celebrating carnival in Maastricht accidentally pours a flugel shot on a Finnish student's phone who was submitting a last second assignment. The phone breaks, Finnish student does not manage to submit the assignment, fails the course, wants to sue the Italian tourists. Okay. The Italian tourist obviously is just traveling through Maastricht for carnival. He is domiciled in Italy. Where can the Finnish student initiate proceedings? Exactly. I'm happy, guys. Yes, there you go. Italy or the Netherlands. Good that you're remembering both of the things. I'm glad about that. Okay, so yes, the answer is either Italy or the Netherlands. So Article 7.2 states that in matters relating to torts, delict, or quasi-delict, in the courts for the place where the harmful event occurred. Okay, so that is the Netherlands because that is where the harmful event occurred. Um, Sir, one more answer. Is Finland also allowed? No, okay, so Finland in this specific scenario would not be allowed because there is no connection to Finland per se under the regulation. So, Mila, instead, maybe imagine a situation in which it is in which it is the Finnish students causing a harm to the Italian tourist, then the Italian tourist would be allowed to sue the Finnish students in the courts of the member states where they're domiciled. And if that is Finland, then they would be allowed to bring the case, the disputes to Finland. Okay. But since here we have the defendant, the Italian, who is clearly the defendant, what the regulation says is that a defendant may be sued in, no, a defendant has to be sued in the courts of their member states. So here, Italy, with the exception being that in the situation of a tort, they may also be sued in the member state where the harmful event takes place, which is the Netherlands. So in this specific scenario, Finland does not apply. If it were the other way around and the Finnish student were the defendant, then they could be sued in Finland. But thank you for your question. And if you guys have any questions at all times, please feel free to drop them in the chat. And obviously also the microphone if you guys want. I know people don't like talking too much into the mic, let alone turning on the camera. If you guys feel like it, do it, but I'm not going to ask you guys more than twice to do that, so don't worry about it. Okay, let's take a look at weak party disputes. Okay, so I will go through it a little bit more by voice. Here on the slide, I just have the general articles involved. If we go, because these are quite long, so I don't want to take up too much of the time for this free tutorial with this, because I also want to focus on choice of agreements, choice of courts, agreements, and so on. But basically, for weak party disputes, what you need to know is that there are separate jurisdictional provisions incorporated in the Brussels regulation for this, and it is usually to address disputes where one party is presumed to be in a significantly weaker position, which would require heightened procedural protection. Okay, so if we imagine, for example, a consumer dispute, so let's imagine that a private individual, a consumer, is trying to sue a corporation. Quite obviously, the corporation is going to have a lot more financial freedom and perhaps also legal and technical knowledge to move around member states for disputes. Okay, whereas maybe instead of the consumer always had to sue where the corporation is headquartered, that would be quite unfair towards the consumer because maybe, like for example, maybe it's a lower income person who has suffered a severe harm because of a product they bought, and it would be quite unfair to expect them to go into the home country of the corporation, where the corporation is domiciled, in order to sue them. Also, because the corporation not only would have the financial advantage of not having to move around, but they would also maybe have the technical knowledge of their own legal system, which would put them at a quite an undue advantage. And as we know, Europe is very much centered towards the rights of individuals. Okay. So these provisions are found for insurance disputes from Articles 10 to 11, for consumer disputes from Articles 17 to 19, and finally, on individual employment contracts from Articles 20 to 23. And they aim to shield the weaker party from being subjected to legal proceedings in member states other than their own. So importantly, what these rules afford the weaker party is the option to initiate legal action in their own member state, even if the defendant is domiciled elsewhere. Okay, for this enhanced protection to apply, the weaker party must be domiciled in a member state. Okay. Um, so the jurisdictional provisions for weak party disputes are largely self-contained. What I mean by that is that they're almost like a regulation within the regulation, in the sense that here, the general jurisdictional rules, like the one that we were looking at before, so Article 4, that says that a defendant must be sued in the member state in which they're domiciled, they do not apply because obviously that would be unfair in this scenario, as I was just outlining before. If a consumer wants to sue a corporation, for the reasons I said before, it would be unfair for them to expect to go where the corporation is headquartered or domiciled. Okay. Then there are some technicalities as to, for example, insurance disputes, whether insurance are covering large risks of mainly commercial nature or other forms of insurance. Um, but these are also a little bit too specific, both to go through in undergraduate lectures and even just to go through a free tutorial. Um, Also, privileged treatment is extended to consumers, as I was mentioning before, specifically individual natural persons acting outside their trade or profession. Okay, and this excludes plaintiffs acting in pursuit of their business. So that means that, like if I'm an individual, but I'm acting as a business, so for example, I run my own business and I acquire products. So for example, let's say that I run my own um computer selling business out of my garage, and I have a registered company, and I buy large computers from a corporate. I buy a large amount of computers from a corporation. If I then sell them around and one of these computers does not work, I am not entitled to the weaker party protection because I am acting in pursuit of my business. If instead I am simply an individual, I need a new computer for school or for work or for gaming or for whatever reason, um, then there I qualify as a weak party, and I would be allowed to make use of these weak party protection schemes. Um, so consumers are granted the right to sue the other party in the courts of their own member states, uh, other than the defendant's member states of domicile or the courts where the consumer is domiciled. Okay, so for example, like if I once again coming back to the computer example, if I am if I am once again, guys, I know I use Italy constantly. I'm sorry, I'm Italian. What can I do about it? Like it is my place of domicile. But if I am domiciled in Italy and I buy computers from a Spanish computer company, I buy one computer from a Spanish computer company. It comes, it is broken. I am allowed to sue the Spanish company within the place I'm domiciled, which is Italy. I would also be allowed to go all the way to Spain to do that, but I would not be very likely to do something of the sort because it would be way cheaper for me to do it in Italy. Um, there are also some procedural advantages that are given under specific circumstances, notoriously, like installment sales of goods, but that also is kind of specific. Um, And one thing to remember here, the only exception from the weak party disputes rules are situations in which the dispute involves immovable properties. Okay, so wait, I see a question coming up in the chat. Okay, Luca, that is an extremely valid question. For the fact that I'm studying in the UK right now, that would be my place of domicile. Yes, that is correct, actually. Usually that is correct to an extent. It is a valid question, but usually European laws have so many intricacies as to how much time you have to stay from outside of Europe in order to, like not be domiciled in a place anymore. Not to make it more complicated, but like I'm officially domiciled in Luxembourg because that is where my registered address is. That is where my family lives. But to make it simpler, like let's imagine all my family was in Italy. I grew up in Italy. I have a permanent address in Italy. That is theoretically where I'm domiciled because domiciled also comes down to national laws and to, like Italian laws and so on. So that is a valid question. That is also up for, like debate and in other scenarios. But for this class, for the time being, all you really have to worry about is the most basic facts that the questions will give you. But it is a very perceptive question, so thank you for asking that. Um, so what I was saying is that one of the exceptions to weak party disputes is when there are disputes concerning, for example, rights in immovable property. But I will briefly explain it here. I think it also comes up later in the presentation, so we will look at it later. But for example, let's imagine that it is a right concerning the ownership of a building that is in Sweden. Then it doesn't matter if I am a consumer in domiciled in Italy and there's a corporation domiciled in Spain, because the property, immovable property, is in Sweden. That is where the dispute will happen. But that once again is a technicality that I would never ever expect your examiners to ask you about. Okay, so I think this is a good moment to take a 5-minute break. So far, we have gone through general jurisdiction rules. Next, we're going to look at choice of court and exclusive jurisdiction. I doubt that we will get to Rome 1. So I encourage you guys, of course, to attend all the other seminars I'll have to do on this. But as you can see, this takes some time, but it's also to be the most complete possible to give you guys a proper idea as to what is going on in this first half of in this Brussels regulation. Okay, so thank you, and I will see you guys at 7:25. So see you guys soon. Oh, the training will go on until 8 p.m. So my 7 p.m. So 42 more minutes. Okay, so let's meet at 25 and we'll have around 35 minutes to go through choice of chords agreements. Thank you guys. All right, guys. Welcome back. Mm, I hope everyone is back. Okay. So next, I would like to look at exclusive jurisdiction first. Oh wait, I forgot about these exam questions. We can skip these for now so that we can actually focus on more stuff. Sorry, give me 1 second. I guess I went a little bit ahead of myself here. Okay. All right. Exclusive jurisdiction. Okay, so what does exclusive jurisdiction mean? So exclusive jurisdiction means that in certain disputes, some member states will always have jurisdiction, irrespective of the domicile of the parties involved. Um, and this we can see in Article 24. Um, so, for example, we have here proceedings concerning the rights in rem in immovable property, or proceedings concerning the validity of entries in public registers, or proceedings concerning the registration or validity of patents, trademarks, designs, and other industrial or intellectual property rights. So the only one that we should focus on right now is the rights in rem in immovable property. Okay, so remember that here, when we're looking at Article 24, the main rule in Article 4, in Article 7, or the special jurisdictional rules in Article 7, or jurisdictional rules on weak party disputes between Article 10 and 23, do not apply when we're looking at Article 24. Okay, so here let's imagine that Emilia asks, will we get the slides afterwards? I think so. I was talking to one of your colleagues before. I need to ask marketing to add me to whatever Athena Studies group chat there is for you guys right now. I assume there is one for year two. And so I need to ask to be added to that one. And once I am added, I will make sure to send the slides in the group chat. Either way, I will text my boss after and ask him about getting the slides to you guys. Okay, so here, let's look at proceedings related to rights in rem in immovable property or tenancies of immovable property. So these disputes and these proceedings must exclusively occur in the courts of the member state where the immovable property is situated. There are a couple of exceptions to this, but we do not have to think about them. But the European Court of Justice defines rights in rem as those having effect against everyone, also known as erga omnes, such as ownership. Okay, so as we see in the example there, in a dispute concerning the ownership of a building situated in Sweden, Swedish courts will have jurisdiction regardless of the domicile of the parties. So, for example, here, I'm just going to use your name, Emilia, because it's the freshest in my head. You just asked the question. So, for example, Emilia and I have a dispute, and I'm domiciled in Italy, and Emilia is domiciled in France, for example. And I have just bought from her a property that is in Croatia. I've just, I bought from her like a beautiful summer house in Croatia. And Emilia tries to say, well, you know what? Actually, Eduardo did not buy this property properly from me, so he is not the true owner of this house. This is a dispute regarding an in rem rights, so ownership regarding an immovable property. And since the property is situated in Croatia, that is where we must have the dispute. So it does not matter if I want to sue Emilia. I cannot sue her in France. I cannot sue her in Italy. I cannot sue her anywhere else other than where the property is situated. Okay. Um, Yeah, we also have proceedings concerning the validity of entries in public registers, such as land, ship, or aircraft registers. These must occur in the member states where the register is kept. And then finally, we have proceedings concerning the registration or validity of patents, trademarks, designs, and other industrial or intellectual property rights, and they must take place in the member state where the register is kept as well. Um, so here, I think it is more important for you guys to focus just on the immovable properties one. Either way, the rules are immovable property where it is situated and with public registered registers or registration of patents or so on, or intellectual property rights is going to be in the member state where the stuff is registered. So, does the exclusive jurisdiction apply even in spite of party agreements? Now, this is an extremely perceptive question. And thank you, Vilmos. Actually, this is also even getting ahead of ourselves a little bit because we will look at choice of courts next. So, what we will see now is we will look at choice of courts. For anyone that is not familiar with it yet, don't worry about it. We'll look at it in the next slides. And the answer, Vilmos, is yes. Because, so the answer is it will, exclusive jurisdiction will apply even in spite of party agreements. Because it would be contradicting for the regulation to set up these rules, for example, around property, it would be contradicting for me and once again to bring the name again, Emilia, to have a dispute in France about a property, about the ownership status of a property that is in Croatia. Why? Because when it comes to immovable properties, national laws are very specific as to how things work. There is not an autonomous interpretation of ownership itself, and that is why we must do it in the state where the property is located. But thank you for that question. That is a very good question, Vimos. Um, okay, so next, let's look at what Vilmos was hinting at. So, choice of courts agreements. This is also known as prorogation of jurisdiction. So these are agreements made between parties regarding the courts in a member state that will have jurisdiction to settle their disputes. And these agreements are valid and enforceable under Article 25 of the Brussels Regulation. So such agreements typically will designate a particular court or specify the member state where adjudication will occur, which will then leave the determination of the particular courts itself to the member state. So choice of courts agreements can also be utilized for pure derogation, which allows parties to exclude the jurisdiction of courts in one or more member states without indicating the specific court that will have jurisdiction. So, for example, let's imagine that Vilmos and I have a contract and we decide to include a choice of court clause. This clause could look like either one, it could look like so regarding any dispute that arises shall be settled in a German court. So that is an option. Instead, another form of the choice of court agreements that it could look like, once again, we make one and it says any dispute that arises shall not be brought before a German court. Okay, so then that works as a derogation. So we are saying not this member state. Okay, so we can either design a member state where we want the dispute to take place in, or design a member state where we do not want the dispute to take place in. However, and this links back to the question that Dimos was asking before, there are certain restrictions. So, for example, the choice of courts agreement must not deviate from the regulations rules on exclusive jurisdiction or mandatory jurisdictional rules concerning weak party disputes. Okay. And so we already discussed briefly why it cannot derogate from exclusive jurisdiction rules, but let's think about it for weak party disputes. Can anybody think why, if anybody feels like it's right in the chat, why choice of courts agreements cannot be used for weak party disputes? So why, for example, a corporation could not use a choice of courts agreement with a consumer? Exactly. Thank you. So it is a matter, Vilmos here says that it is a matter of power imbalance. So that is the main thing. Um, so imagine there's only one provider of laptops in Europe, and I desperately need a laptop. There would be a severe power imbalance in which I, as a single consumer, if the producer of laptops does not gain me as a customer, it would be insignificant because they have a huge pool of other customers to sell to. But instead, for me, it would be extremely important because I would really need that laptop. And so there is a power imbalance, and that is the one of the reasons why. Another thing that we can maybe think about is that also as a private individual, as a consumer, I might not be an expert in law, you know. I cannot be expected of maybe reading the terms and conditions of something entirely before I accept it because they're extremely long. Yeah, exactly, Luca. So it's like you're saying, would create a loophole for more powerful parties to create unfair contracts, right? So it's what we were looking at before. Like a corporation would have such an easy time being sued in their own place because they have the money to handle it and they have the expertise to handle it, okay? And so it would be unfair to put in a choice of court, for example, in the terms and conditions. So you guys have seen what terms and conditions look like. Like these agreements can be 150 pages long. So if I'm, buying a product for a corporation, am I really going to look, even as a law student, like, am I really going to look through 150 pages of terms and conditions? Like we have to accept terms and conditions for literally anything nowadays. So if we had to go through all of this and pick up on a choice of court agreement, that can also not be expected of us. So that's another reason why it cannot deviate from mandatory jurisdictional rules concerning weak party disputes. And finally, the choice of courts must pertain to disputes arising from the legal relationship connected to the agreement. So let's imagine that Luca and I enter into a contract for for the sale of a couch, okay? And we say for any disputes arising out of this contract, the proceedings shall take place in Bulgaria, in a Bulgarian courts. If, I deliver the couch to Luca and Luca believes that the couch is not up to par with, like the couch I advertised to him, it's a different couch or so on, and he wants to sue me, then he will have the right to sue me in Bulgaria. Okay. But if instead, let's imagine something else happens, like for example, I have delivered the couch to Luca, the contract has been effectuated, and then on my way out, I accidentally scratch his car, then that is a dispute that does not arise out of this contract, right? So it is not tied to the choice of courts agreement. So there it would be, back to the classic rules of domicile and maybe Article 7.2 of tort and so on. Okay, so the disputes must pertain to the choice of court must pertain to disputes arising from the legal relationship that is connected to the agreements. Importantly, also, it's important to note that it does not require both of the parties to be domiciled in member states. Also, another thing that is good to know is that the validity of the choice of contract is independent of the validity of the overall contract. Okay. So, if for some reason the contract is deemed invalid, the choice of courts agreement will still be valid, which means that if I said with someone, okay, this dispute will be brought under French courts, and then the contract that contains the dispute, there's a risk of it being invalid, we would still have to bring it to a French court, and then it would have to be the French court to say, okay, this contract is invalid, but the agreement, the choice of courts agreement is still valid, so we shall rule over what the consequences of the invalidity of this contract will be. Um, so there are three accepted forms of agreement. So one is that the agreements may be written or evidenced in writing. Okay. For example, a contract written by hand, or it might be in a form which the parties have established and agreed to. So also an oral recording might be okay. And finally, a form recognized in international trade or commerce. Okay. Um, so yeah. And also keep in mind when looking at a written agreement, also electronic communications can be considered to be an electronic agreement. All right. Um, any questions? Any questions about Article 25 before I move on to Article 26? Is it clear for everyone how choice of courts agreements function? Okay, I'm going to take the silence as a yes, and I will assume that you guys are now experts on choice of court agreements, and I will move on now to tacit prorogation. Okay, so what is tacit prorogation? It is a concept introduced by Article 26, which is whereby the defendant enters an appearance without contesting the court's jurisdiction. It's a complicated sentence. Let's break it down with an example. So a Polish defendant may have the right to having proceedings against them initiated in Poland. However, if they make an appearance at the Danish court and they do not contest its jurisdiction, then the Danish court will have jurisdiction. Okay. Um, so that's pretty much the main concept of tacit purgation. Any questions about that? Do you guys want me to go a little bit more in detail, or is that enough for tacit purgation for you guys? Okay. All right. Then let's maybe quickly look at two questions here. So far we have gone through general jurisdiction and choice of courts and exclusive jurisdiction. I will maybe quickly ask you guys two questions, and then with the last 10, 15 minutes, we can look at the beginning of the Rome regulation just to quickly cover its scope before ending this tutorial. Let's imagine this scenario. So Victoria, a freelance photographer domiciled in Spain, signs a contract with an Italian fashion magazine to provide photographs for their monthly issues. The contract includes a choice of courts clause specifying that disputes will be adjudicated by the courts of Milan in Italy. So when the magazine fails to pay for Victoria's work, she decides to sue. However, instead of filing in Milan, she brings the case to the courts in Barcelona, in Spain. The magazine participates in the proceedings in Barcelona without contesting the court's jurisdiction. So analyze whether the court. So let me ask you guys first. Is the choice of courts agreements binding under the Brussels regulation? Let's imagine that the choice of courts is included in a written contract. Okay. Uh, is it binding? This is not a. I promise you, I'm not asking you guys a trick question. I'm not trying to trick you guys out on this one. Okay, that's interesting, Mila, that you bring up that it is a weak party dispute. Um, as I mentioned, it is not a trick question. I wasn't trying to trick you guys, so it does not actually concern a weak party dispute over here. Um, so it is binding, actually. Maybe it seems like a weak party dispute here because we did discuss briefly that employees can be weak parties, but another branch of EU law specializes on whether workers like Victoria do count as employees or not. And here, because she is a freelance photographer, you can safely assume that she is not an employee, and thus she is not a weak party dispute. She is not a weak party. She isn't either a consumer because she is actually providing a service here to an Italian magazine, and she is also not an insurance. And on top of all of that, she's acting in the course of her business. Okay, so she is not a weak party. Therefore, there is not a weak party dispute. And yes, so yes, the choice of courts clause would be valid, provided that, it's provided that it meets the formal requirements. And since here we have a contract, we can assume it's written, and thus it does match the formal requirements. Now let's look at the second part. So can you very briefly, one sentence, 3 words, 4 words, 5 words are enough, explain the legal implication of the magazine's tacit purgation by participating in the Spanish proceedings without contesting jurisdiction? What does that mean for the Spanish courts? Does it have jurisdiction? Does it not have jurisdiction? Okay, so the answer is that it would have jurisdiction, right? The Spanish one. So because the magazine participated in the proceedings in Barcelona without objecting to the Barcelona jurisdiction, which let's remember it could have done because the choice of courts agreements determined that Milan and therefore Italian courts were the place where to bring the dispute. But by failing to object to this jurisdictional issue, the magazine has in fact waived its rights to rely on the choice of courts agreement, and therefore the Spanish courts would have jurisdiction. Um, okay. Very briefly, let's look at the steps I outlined for understanding these answers. So, first, for the first question about the existence, about the bindingness of the choice of court agreement, the first step is to confirm the validity of the choice of court agreements. So under Article 25, a choice of court agreement is binding if it is in writing, evidenced in writing, or follows a form established between the parties. Check, we have it. It is in a contract. And second, if it designates the courts of a member state, such as Milan in this case, it doesn't have to designate the courts, it can just designate a member state or it can exclude other member states. Check, we have this. It says that the dispute shall be brought in the Milan courts. So the agreement in this scenario meets these requirements. The second step is to consider whether the clause applies to the disputes. And the clause relates to disputes arising from the contract, which includes payment issues. Thus, it is binding and it applies to the case. So the conclusion is that the agreement is valid and binding, and the disputes should ordinarily be brought to Milan. Then on the second question, what are the legal implications of tacit prorogation? So the first step is understanding tacit prorogation, right? Article 26. So if a party appears in court without contesting jurisdiction, the court assumes jurisdiction unless it contradicts exclusive jurisdiction rules or mandatory protection for weaker parties. So Mila reminded us of a very good point, which is that if there is a mandatory protection for weaker parties, then tacit prorogation or choice of court agreements will not be valid. Okay. But here in this scenario, there was not a weak party, and there was also not a dispute relating to exclusive jurisdiction. Thus, tacit prorogation did in fact happen. So let's apply tacit prorogation to the scenario. The magazine participated in the Spanish proceedings in Barcelona without contesting jurisdiction. So by doing so, it tacitly accepted the jurisdiction of the Spanish courts. So the third step would be to resolve the conflict between the choice of court clause and tacit prorogation. What this means is that while the choice of court clause is valid, tacit prorogation would then take precedence in the situation because the magazine has, in fact, waived its rights to invoke the agreement by not objecting in Barcelona. So the Spanish courts gains jurisdiction due to the magazine's tacit prorogation, uh, despite the choice of courts clause favoring Milan. So Naz asks if Article 26 is not under Article 25 in terms of hierarchy. That is actually a great question. And if you are correct, if you're looking at the hierarchy in front of you right now that your class has given, that your teacher has given, please do let me know. As far as I recall from my course, Article 26 does precede Article 25 because it relates to, well, this concept of tacit prorogation pretty much. So the whole point of Article 25 is to promote a concept called party autonomy, which means that parties to a contract may decide for themselves how the contract works. And this includes choosing um, what member states will, in fact, rule on the dispute. So in respect of this whole party autonomy concept, if uh if a party to the contract tacitly prorogates jurisdiction, so if the party to this contract here, in this case, the magazine, goes and starts disputing in Spain, what European law assumes, what the regulation assumes, as far as I recall, is that it is now to be interpreted as their will that they, in matter of fact, want to have the dispute in Spain. So they're not forgetting that they have a choice of agreements because like they have lawyers, they have people looking over this stuff. So they're not simply forgetting it, but maybe they realize that it is in fact in their favor to have this dispute in Spain, simply because maybe they're domiciled in Spain. So to them, it is easier in this scenario. Naz, if you do have the hierarchy in front of you, maybe in that they gave you during a lecture, please do let me know. You can also PM me if you want, and then I will correct myself. But for the time being, do consider that uh, tacit prorogation takes precedence to Article 25, so to choice of courts. Okay, so we're actually nearing the end of our time, so maybe we will have time to look at one more question together and to go through the answer together. Very briefly, before we do that, I would like to ask you guys the quick favor of scanning this QR code. It will bring you to an evaluation form where you can evaluate me as a tutor. If you think I did a good job, please let me know. If you think I did a bad job, please let me know how I can do better. There are a couple of basic criterions, and then like a little box where you can put in your opinion. It would be greatly helpful to me as a tutor, to my employers, as my employers, as I mean to Athena, as my employers, so that we can figure out if there's anything, that I'm doing right or I'm doing wrong, so we can see how to keep it up. So I would be extremely grateful if you guys could scan this QR code and fill in that evaluation form. It really takes less than 2 minutes. It's just like 4 or 5 questions. It's ratings 1 to 10. 10 is the best, one is the worst. And you guys can just answer like that. You don't have to put in any personal comments if you don't want to. And it would be extremely useful to me. So I'll leave that on for 30 seconds while I look for one last question to maybe look at with you guys. So if you can, please answer that. Okay. Thank you, Mila. So yeah, it does make sense that Article 24 is above Article 26, for the same reason that Article 24 is above Article 25. So this is what we were mentioning before. So Article 24, let's remember that is exclusive jurisdiction, so linking back to the property. So as I was saying before, if I'm domiciled in Italy and I have a dispute with someone who is domiciled in France over the ownership of a property that is situated in Croatia, Croatian courts will have jurisdiction over it. And no worries, Naz. It was a totally valid concern. But thank you guys for confirming to me after that it was nuts. Okay. Very quickly, I won't put you guys through the efforts of answering the question yourself. We'll quickly look at an exam question and then we'll go through the answer together just to top off this this tutorial together. So let's imagine a situation in which Marina, an artist domiciled in Italy, commissions a French web developer, Lucas, to build her online gallery. The contract specifies that the website should be ready within 6 months, that the service of website creation should be performed in Italy, and that payment will be made in 3 installments. Okay. Marina also purchases a server from a Dutch company which agrees to deliver it to her studio in Rome. After 6 months, Marina discovers that Lucas has only partially completed the website and the server delivered by the Dutch company is defective. So the first question is, under the Brussels regulation, determine where Marina can sue Lucas for breach of contract and where Marina can initiate proceedings against the Dutch company. So I know that questions like this sound maybe a little bit daunting or complicated. They have a lot of details in them, and so they sound over the top, but really there's just a few things that we have to focus on over here. So the answer to the first one is that Marina can sue Lucas in France or alternatively in Italy. So Marina could sue Lucas in France because Lucas is domiciled in France, and therefore the main rule, Article 4, applies. Okay. Uh, the alternative, which is Italy, would be because that is the place where the services were to be performed. Okay, so the creation of the website is to be performed in Italy, so that is under Article 7.1b. Oh yeah, I even have it written here. So under Article 7.1b, it would be the place where the service is to be performed as the member states in which the dispute can be brought. Instead, where Marina can initiate proceedings against a Dutch company, here once again, the Dutch company can be sued in the Netherlands under Forum Domicili under Article 4, or finally, Italy also themselves, because that is the place of delivery of the goods, which also is still under Article 7.1b. The member state where the goods are to be delivered is the member state that will have jurisdiction. So the second question was, assume Lucas disputes the existence of a contract, claiming that no agreement was reached on the payment terms. How does the Brussels regulation address jurisdiction when the validity of a contract is contested? So here, in case of of contested contract validity, jurisdiction would still be determined under Article 7(1) as the dispute relates to an alleged contractual obligation, assuming that there is evidence of Marina's reliance on contract. So if no jurisdiction could be established, then the default rule of Article 4 would apply. But so remember, even when the validity of a contract is being disputed, it will still be in the case, for example, of the jurisdiction will still be determined under Article 7(1), which is what pertains to contractual obligations. Okay. And with this, I would like to end the tutorial here. I want to thank everyone for participating, for the people who talked, for the people who contributed. Thank you very much. I will be teaching the rest of the private